Good morning and welcome to AIADA's AutoTalk. I am Dan Barson, your host for this morning's program. Held the third Tuesday of each month at 10 a.m. and 4 p.m., please plan on joining us for these quick 20-minute presentations. Before I introduce today's guest, let me cover a few administrative issues. First of all, you will all receive a copy and a recording of today's program before the end of the week. If you should have any questions, please feel free to enter those under the Q&A in the bottom right side of the page. If you have any additional staff that you feel would really benefit from this morning's program, please have them join us again at 4 p.m. Eastern Standard Time. And make sure and stay on the call after today's speaker to hear about several really important upcoming programming announcements that we have. Now, let me introduce today's speaker. It's Rob Byerts, attorney from Bass Sox Mercer. Rob has been with Bass Sox Mercer since 2003 and been involved in dealer issues since that time. Rob, welcome to the program and take her away.
Thanks, Dan. It's a pleasure to be with the association today and to talk about recalls. The headlines, of course, give you plenty of ammunition. General Motors recalls 1 million Chevy and GMC trucks. Mazda recalls vehicles that may lose steering controls. Honda recalls Accords to fix passenger airbag problems. We see all the headlines. Some of the statistics indicate that the Takata airbag recall has reached 20 million vehicles. And it's not just one brand. We've got vehicles affected across the board. The VW diesel recall is another well-known recall issue affecting dealers. Most dealers don't realize exactly what law applies, and we're here today to talk about what the law says and requires with respect to new motor vehicle recalls. One of the most important things to take away from today's webinar is the instances in which the dealer may not sell the vehicle. Not all recalls restrict a dealer's ability to sell a vehicle. When they do, the manufacturer is supposed to compensate dealers. If I was in a room where I could see everybody's hand, I'd say, raise your hand if you're getting money from the manufacturer right now. If you're not getting money from the manufacturer right now and you have a stop sale recall notice that affects part of your inventory, you may be wondering what you can do. The law is different for recalls with respect to new vehicles and used vehicles. The recall restriction on new vehicles is fairly well known. If you have a vehicle that is in your inventory that is a new motor vehicle and has been identified as the subject of a recall related to a safety issue in particular, then you cannot, under federal law, sell that new vehicle. What about used vehicles? Used vehicles are different. Federal law does not restrict the sale of used vehicles that are subject to a recall notice. Many dealers are surprised to hear that, but that is the law. Let me repeat it again. Federal law does not restrict the sale of used vehicles that are subject to a recall notice, safety or otherwise. Now, there are restrictions out there on some used vehicles, and we'll talk in a little bit about what the best practice is with respect to used vehicles, both the used vehicles that you sell associated with your franchise and the used vehicles that you sell from other brands. Recently, the National Highway Traffic Safety Administration indicated what it prefers with respect to the sale of used vehicles. It would prefer that dealers do not sell used vehicles that are subject to recall notices, particularly safety recall notices. They issued a consent order with respect to Chrysler, primarily because Chrysler was advertising, and Chrysler dealers were advertising, vehicles under the certified pre-owned moniker as having undergone a comprehensive check prior to being marketed for sale. Some of the vehicles that were being sold as certified pre-owned by Chrysler dealers, ostensibly having undergone this extensive safety check, had stop sale recall notices on them. The National Highway Traffic Safety Administration's consent order with Chrysler restricts Chrysler's ability to market those vehicles and requires Chrysler to incentivize dealers to stop selling used vehicles subject to stop sale recalls. Manufacturers generally do not want used vehicles that are subject to stop sale recall notices sold. Of course, plaintiffs' attorneys will pursue both the dealer and the manufacturer in instances in which a sale of a vehicle subject to a stop sale recall occurs and an injury happens. Generally, the lawsuits do not result simply from the sale of the vehicle. Generally, the plaintiff's personal injury attorneys want to recover damages, and that means injuries. Of course, earlier this month, there was another airbag injury in Texas, a death, and so the issue is topical. The opportunities are going to continue to be there, and the best practice is to try not to sell to retail vehicles that are subject to a stop sale recall. In instances in which that unfortunately happens, you do risk factory indemnification. The factory is not going to come in and stand behind you. At least they're going to try not to come in and stand behind you in instances in which you sell vehicles that are subject to a stop sale recall. You may have a dealer agreement with your manufacturer that includes an indemnification requirement in instances in which the product does not perform in accordance with the warranty. That indemnification requirement is not going to apply. At least the manufacturer is going to try to get out from under it in instances in which a dealer sells a vehicle subject to a stop sale recall. And that's whether or not the vehicle you sell is one manufactured by the manufacturer you represent or not. And it's not just Chrysler. Lithia and Jim Kuhn's management and GM have also entered into agreements with federal agencies related to cars that were subject to stop sale recalls but were nonetheless sold without being repaired. The Federal Trade Commission went after General Motors and Jim Kuhn's management and Lithia because those operators and that manufacturer touted rigorous inspection of the vehicles, certified pre-owned and otherwise, that were sold, even though those vehicles had unrepaired safety recalls present. Those orders with Jim Kuhn's and Lithia and GM now clearly prohibit the sale of used vehicles subject to stop safety recalls and being advertised as safe or subject to rigorous inspection unless the defect has been remedied or unless you say in the ad there may be recalls applicable to these vehicles. Now, nobody's going to do that, I don't think. So the operative takeaway from those enforcement actions is do not sell vehicles subject to safety recalls and advertise them as having undergone a rigorous inspection. So what do you do? Well, you realize that under your state law, the Deceptive and Unfair Trade Practice Act that exists in your state, you could be subject to the same sort of enforcement action by a regulatory agency or subject to a lawsuit from a plaintiff's attorney if you advertise the vehicle as certified pre-owned or having undergone a rigorous inspection or any inspection at all when that vehicle has unremedied safety recall defects. In fact, in most instances, state law prohibits the representation of the prior condition of the vehicle unless you have information to support that. You should not advertise vehicles as having undergone rigorous inspections or having a clean history unless you have some information to support that. The corollary, of course, is if the information that's there indicates that there is an issue, you would really have a problem advertising the vehicle as having undergone a rigorous inspection or otherwise being ready to go. There are ways to look that up. Safercar.gov allows you to do a VIN lookup. Right now, we don't know of any way to determine in bulk what vehicles are subject to the safety recall. You can go to the safercar.gov and see various listings. The Takata lists in particular have been broken down. If you have a franchise with the manufacturer, you can, of course, check that information source for what vehicles are subject to recalls. But you need to run the vehicle regardless. You may have vehicles come through the service lane that are subject to recall. In evaluating a vehicle when it comes to the service lane, you should check them against those resources at safercar.gov and with your manufacturer to determine whether or not the vehicle in the service lane is subject to a safety recall. If it is subject to a safety recall and the issue is not identified and hopefully addressed as part of servicing the vehicle, those plaintiff's attorneys and those regulatory agencies are going to turn around and say the vehicle came across your lot, it came through your service drive, you do or should have known of the existence of the recall, and you didn't do anything about it. So be sure you have a process in your service lane to identify vehicles coming through the service lane that are subject to a manufacturer recall, in particular a safety recall. If there is no manufacturer direction, you at least want to get a customer acknowledgement. Now, we don't think a customer acknowledgement is the best way to do this. The best way is to take the customer out of the car. Honda, in fact, requires the offer of a rental car or a loaner in instances in which you have a customer come onto the lot with a vehicle that's subject to a safety recall. A customer acknowledgement is better than nothing, but the best practice is to put the individual that brings the vehicle onto your lot in the service drive or otherwise into another car. And by customer acknowledgement, I mean a document that reflects that you have looked into whether or not the vehicle is subject to a safety recall, you've identified the vehicle as subject to a safety recall, you have advised the person bringing the vehicle to you of the existence of a manufacturer recall, and you have offered to take the customer out of the car, and they've declined and are driving the car with notice of the existence of the safety recall. Again, that is not the best way to protect yourself, but it's better than nothing. What about lease vehicles? You've got customers out there in leases. Some of them are bringing the vehicle back to you and want to exercise the contractual right to purchase. It says right there on the document, the customer may even point out to you, I've got the right to purchase this vehicle. It's not something you would normally get in the way of. But particularly if you're a Honda dealer, but also other manufacturers with other recalls have said similar things, you should not sell the vehicle to the customer. You should offer the vehicle available as a loaner car, as a rental, and take the vehicle that is subject to the safety recall. And if the customer balks, Honda in particular wants to know about it, and the fallback position is still a document reflecting you've told the customer the existence of the safety recall, you have advised the customer of the availability of a loaner, and you have nonetheless had a customer decline to take you up on that particular offer and want to drive the vehicle away anyway, and in this instance, because it's a leased vehicle, want to exercise their right to purchase. Well, thankfully, the bank is going to be the one dealing with it and not the dealer. So I think for off-lease vehicles, the advice to the customer is still the same, but the liability issue is a little bit different because it's no longer your vehicle. It did come across your lot. You do need to advise people of the existence of this information and offer the remedies available. But if they decline to do that, you should at least document. And if the customer declines to sign off on a document that you have reflecting you've provided this advice and acknowledging that you'd offer them an alternative, you still need to make a note in a file somewhere. Document somewhere so that if that customer comes back and has an unfortunate incident and files a lawsuit, your attorney is going to say, did you ever see this vehicle? When you saw this vehicle, what did you say to these people? And it will be helpful if you make a record of that. If you have vehicles on your lot in the used vehicle, pre-owned vehicle, part of your display, I hope you've looked at them and determined which ones are subject to a safety recall and taken them off the front line. I hope that you've taken the minimum amount of steps necessary to find those vehicles and handle them appropriately. The best practice is to take them offline, and if you can get them repaired by the franchise dealer, get them repaired. If you're stuck because the parts are not available, then there are alternatives. You can take them in many instances and wholesale them. Some of the auctions are doing that with notice from the submitting dealer of the existence of a recall, but some of them are doing it without that. There are alternatives in the instance you get stuck with these vehicles or take one in trade that you can't get repaired because the parts are not going to be here until the summer of 2016. But the best practice is still identify those vehicles. If you can get the vehicle fixed, get the vehicle fixed. If you can't get the vehicle fixed, idle the vehicle. If you can't idle the vehicle and the customer's driving away, get the customer to acknowledge you've told them about the existence of this recall, that you've told them about the remedies that are available, and that they have chosen nonetheless to drive away with that vehicle. There has been some states that have taken some steps. Maryland and Virginia require a dealer to run a recall before the sale of a new or used vehicle. You should be doing that anyway. In those states, it is a requirement. In those states, the legislation says the dealer may not sell the vehicle. And in those states, the manufacturer of the grounded vehicle is required to compensate the dealer for the time the vehicle is grounded. That hasn't happened yet in every state. The only two states I know of where it has happened are Maryland and Virginia. But it's certainly on the mind of legislators And if we keep having issues with recalls, I anticipate more states will take action. So, what do you need to be doing? You need to be staying informed. You need to pay attention to the information your manufacturer sends you, and you need to be evaluating your inventory against the information your manufacturer sends you. If you happen to end up with one of those vehicles where an open recall exists, do not deliver it. If it's a new car, do not deliver it. It's against the law, okay? The vehicle should be repaired. Until it's repaired, it should not be available for anyone to operate and drive. And the manufacturer should be providing you compensation for it. Now, I don't think every manufacturer is, but that's what the law says they should be doing. If the situation continues, check back regularly. Some of these recalls are being addressed and cleared. Some of these vehicles' status are changing. You have to keep up with the information. But if it's a new vehicle, don't sell it. If it's a used vehicle, if it's in your inventory and you are a franchise dealer for that line make, you should have that information from your manufacturer. You should have information about the availability of parts, and you should be able to, unless you're in line for airbags, you should be able to fix the car before delivery. If you're in line for airbags and the parts are unavailable, our recommendation is you do not sell at retail the vehicle. Our recommendation is you hold the vehicle or you dispose of it in a non-retail situation. And when you do, our recommendation is you disclose the issue associated with it. If the situation continues and you haven't disposed of it, continue to check against the recall information both on the safercar.gov site and in your manufacturer if you happen to be the franchise dealer for that line make. In terms of other places where you can find out information, I don't have an identification of other places other than the manufacturer information or safercar.gov to obtain that. Now, if you can access the manufacturer information, you can, with some effort, identify what kind of recalls are safety recalls versus non-safety recalls. It should be evident because the notice from the manufacturer will say somewhere in there is a risk of crash and or injury or death, it says, with respect to the airbag issues. So the manufacturer discussion in the notice should indicate whether or not it is a safety issue. Sometimes you got to read a little deeper into it. But the manufacturer notice is where you can distinguish safety recalls versus non-safety recalls. If you get a vehicle in as trade, or if someone comes in and wants to trade the vehicle, you need to review those vehicles against the same information. Review it against your manufacturer information and review it against the website to determine if it is a listed vehicle and if you need to either ground the vehicle or wholesale it or at the minimum get an acknowledgement from the customer or the person you're dealing with that you provided them with that information. Some people are looking at vehicle history reports for that information. Our recommendation is not to rely solely on vehicle history reports, but to check the specific VIN number against the safercar.gov lookup opportunity and against your manufacturer information. So that's what I have to tell you about recalls today. I am interested in any questions that anybody has with respect to recalls. There is an opportunity, and some of you have done that, to input a question into the software and let me know. One of the questions that has come up has to do with other sources of information about recalls, and as I mentioned, safety versus non-safety recalls is not specifically identified on the safercar.gov website. They don't separate them out that way, but if you read into the notice from the manufacturer there or in the information you get directly from your manufacturer, you can see whether or not the basis for the recall concerns the possibility of the vehicle crashing and causing injury. If that language is in there, that's a safety recall. If that language is not in there, it's not necessarily not a safety recall. You have to interpret the language there, but if it's a push-button knob on the radio changer, I don't think it's a safety recall. Another question asks, what about being paid by the manufacturer during times of a stop sale? If there is a new vehicle subject to a stop sale in the United States, federal law says the manufacturer is supposed to pay you. I know I have clients out there that aren't being paid, but that is the federal law. There is a requirement that they either immediately replace the defective part or they purchase the vehicle back from you and provide compensation for the period of time that you've had it. I don't know yet of a manufacturer that is expressly doing that, but that is what the federal law requires. And I think that if you put that in front of their face and demand that, we'll get somewhere with getting it implemented. So that is what the federal law says. Another question asks about that. What about managing the relationship with the manufacturer versus forcing them to compensate? That is a business question for you, and your relationship with the manufacturer is something to manage and to evaluate. From a legal point of view, that's a remedy that's available. From a business point of view, we certainly understand you having to manage that relationship and trying to maintain that relationship despite the fact that the manufacturer is supposed to be doing something for you is a delicate balance. I would like to think that there are others out there that will help us gain their attention and that concerted effort will provoke a response. Can't tell you it's happening yet, but I do understand many dealers are hesitant to pose that question to the manufacturer, and I think unless and until you ask for it, the manufacturer's not necessarily going to give it to you. Now, one of the questions asked about whether or not the floor plan assistance amounts to that. Many manufacturers provide floor plan assistance regardless of recall for a particular period of time, but I know some representatives for some manufacturers have contended lately that the floor plan assistance they are providing now for vehicles that are subject to safety recall notices now is the assistance that the federal law is talking about. I don't have a way to tell you that that is correct or that's not correct, except to say if they were already providing floor plan assistance, I think it would be difficult for them to contend that it is being provided now because of this obligation to compensate dealers for vehicles idled by a safety recall. If they weren't doing it before and they are doing it now, it may be that they are trying to comply with that provision in federal law. I think it's a situation you have to evaluate and look at under the circumstances and see whether or not it appears to be something they weren't doing before and they're only doing for vehicles that are subject to the recall. So I don't have information except I have heard anecdotally that at least one manufacturer is contending that the floor plan assistance it is providing now for vehicles idled by recalls now is an attempt to provide compensation due to the federal law. They haven't identified it that way. It's just anecdotal information.
Robert, I think that was our last question. I want to thank you again for the outstanding information that we saw today and listened to today. If anybody should have any additional questions, please feel free to get a hold of Bass Sox Mercer pertaining to the recalls and the concern over those. Again, everybody on today's call, you're going to receive a copy of today's programming by the end of the week. And also remember, if you feel a staff member would benefit, please have them join us for the 4 p.m. Eastern Standard Time session. Next month, AutoTalk will feature I Hate My DMS and My DMS Provider, and why technology changes and some enhancements just might change your mind. Listen about some exciting platform enhancements, flexible operational options that are available today in many of the offerings that are web and cloud-based. Join us on May 17th at 10 a.m. and 4 p.m. for this short 20-minute discussion. With the election season in full swing, please join us here in Washington, D.C. on May 10th and 11th to attend the AIADA Automotive Summit. This program is a quick day and a half, and guys, we need everyone here to basically convey to your members of Congress the value you bring to your community and your state and your county every day of the week, and the number of folks you employ, and just how important the dealer network is to our local communities. If there's any year that you can make it, this is a year to join us here in Washington, D.C. Again, we look forward to seeing you next month, and have a great remainder of the selling month. We'll see you next month. Thank you very much. Bye-bye.